Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a legal passage of 500 words at the speed of 125 words per minute. So be ready for the dictation. 3, 2, 1 and go. From the aforesaid decisions, it is apparent that while exercising the powers in appeal against the order of acquittal, the Court of Appeal would not ordinarily interfere with the order of acquittal unless the approach of the lower court is vitiated by some manifest illegality, and the conclusion arrived at would not be arrived at by any reasonable person, and therefore the decision is to be characterized as perverse. Merely because two views are possible, the Court of Appeal would not take the view which would upset the judgment delivered by the court below. However, the appellate court below has the power to review the evidence if it is of the view that the view arrived at by the court below is perverse and the court has committed a manifest error of law and ignored the material evidence on record. A duty is cast upon the appellate court in such circumstances to reappreciate the evidence to arrive at a just decision on the basis of material placed on record, to find out whether any of the accused is connected with the commission of the crime he is charged with. In the light of the aforesaid principles laid down, we shall consider the evidence placed on record to find out whether the courts below have committed any error in dealing with the evidence which can be said to be patently illegal. There can be no fixed or straight jacket formula for the duration of time gap in this regard, and it would depend upon the evidence led by the prosecution to remove the possibility of any other person meeting the deceased in the intervening period, that is to say, if the prosecution is able to lead such an evidence that likelihood of any other person other than the accused being the author the crime becomes impossible, then the evidence of circumstance of last seen together, although there is long duration of time, can be considered as one of the circumstances in the chain of circumstances to prove the guilt against such accused persons. Hence, if the prosecution proves that in the light of the facts and circumstances of the case there was no possibility of any other person meeting or approaching the deceased at the place of incident or before the commission of crime in the intervening period, the proof of last seen together would be relevant evidence. For instance, if it can be demonstrated by showing that the accused persons were in exclusive possession of the place where the incident occurred or where they were last seen together with the deceased, and there was no possibility of any intrusion to that place by any third party, then a relatively wider time gap would not affect the prosecution case. We have noticed the decision. However, the circumstances in the present case are not similar to the case where the event of the last seen together has very close proximity with the time and the place of the commission of the crime. Stop.